Hi everyone, thank you for joining us here today. My name's Carly Thorpe. I'm a partner in the construction and engineering team here at Walker Morris. I am joined here today by Jason Sharp and Guy Jackson, who are both of Overford Limited. Jason and Guy are both experienced quantum experts, adjudicators, and they've joined us here today to talk through the adjudication process with me. Now, we're going to go through tips, tricks, strategy, how to make the most out of the adjudication process. We're not going to get into case law in any detail. If you want a case law update, please do look at our Adjudication Matters bulletin. But we wanted to focus today on the types of things that you can only learn through doing adjudication day to day, those sort of tips and tricks that will help you get success. So let's get started, Jason, Guy.
Thanks for having us.
Thank you. Thanks for coming. Let's start at the beginning then. You get presented with an instruction from a client. They give you lots of information and say, is this suitable for adjudication? What do we look at? What do we need to check?
Well, first thing we always look at is there a contractual right to do it, to adjudicate? Is it a construction contract? Is there entitlement? Has it crystallised? And then we look at the value as well. There's a few things there, the main things which check off, but and then the entitlement we look at.
Yeah, I mean, it might be that somebody thinks they've got a crystallised dispute, but in reality, they've probably got a dispute that's not quite crystallised. So when they pass it across our desk, like, you know, I've been notified the other side of the dispute, if you like. It could be an application for payment or just a number of back and forths on email.
Yeah, good point, because if the dispute hasn't crystallised, then you think about, well, let's do a letter to make sure that it definitely does crystallise, so we're taking away that issue. For me, I think it's practical points as well, like who from the client are you going to need to actually help support this through adjudication? When are they on holiday? What time of year is it? Do we need to think about that? And also, what's the best bit of the dispute to refer to adjudication? So sometimes, you know, if you've got like an interim account or a final account with lots of different items in dispute, it might be better to actually just pick one of them that's your strong point and refer that to adjudication rather than the entire account. Another thing, I suppose, is expert evidence. So is it something that before going to adjudication, you should get an expert report on? Now, I personally am a big fan of using experts in adjudication because I think it's so rough and ready and quick that you only get that limited time to put forward your case. And you want the adjudicator to understand where you're coming from. And so I think an expert's really good for that. But, you know, from your experience, both from being experts and being adjudicators, how do you think, what are your tips for getting the most out of an expert during the adjudication process? How can you make the most of their evidence and get it to help you?
Well, sorry, just on that, can I just, you know, go back to a couple of points you made about discrete points of a dispute, and you know, I've sat as an adjudicator on a particular dispute, and the contract clause, interpretation of the contract clause was put forward, and they wanted declaratory relief on that. Because then that could trigger a series of adjudications on variations and the value of variations. But it was important, I think, for the parties to establish the entitlement initially, after, you know, as the variation clause being followed, and that actually would, in reality, save parties money because they're not referring the monetary part of the dispute. So, you know, that's probably one reason why you do see sort of discrete points being referred to adjudication rather than the whole variation account of 300 variations.
Yeah, I think that's right. Like, you think about what's the overall strategy here, and if it's to drive to an agreement on the account, then if you can just get a declaration on one point, that improves your negotiation position. And yeah, like you said, Guy, much cheaper, but also quicker because you're not having to prep hundreds of variations. You're just looking at that one contractual point.
And if you think about it, your adjudicator's only got a short amount of time to make a decision on 300 variations. It's not going to be, it's difficult, isn't it?
Yeah.
You know, it's going to have 14 days to mull it over after all your submissions are in. Yeah, it's a short amount of time.
Yeah.
And then I suppose looking back at the value of expert witnesses, Jason, probably enlighten you on that.
Yeah, we've got, it's important your instructions are right with the expert. It's independence is a big issue with, if you want in a CPR 35 report. Adjudication, you've got to work in the spirit of that. You've got to remain independent. We offer that, independent view, going for, when we're working towards that. It's how that it's how that's shared. I'd look to, if you're looking to do an expert report within an adjudication, I'd look to do that issue, make sure that's being shared with the side first. Before you even go to adjudication, because you get questions of ambush and everything else. So you want to make sure they've seen the other side, so no one's crying foul, there's no breach of natural justice, all that type of.
I think that's a really good point, Jason, that to give, if you're getting an expert report, send it to the other side before you actually start the adjudication proceedings. Because just flipping it, when I act for a responding party, and if you see an expert report, one of the first kind of jurisdictional objections that you can raise is that, well, we've not seen this before, so no dispute has crystallised. And often an adjudicator will still carry on that basis because they'll say, well, that's just extra and the actual dispute is this over here, which has crystallised. But it does buy you more time to get a response in.
We've had adjudicators step down, haven't we?
Yeah, we had one who stepped down because he felt that a quantum narrative, which had been prepared, actually changed the dispute, but it actually didn't. The dispute was still a particular valuation cycle. It's just that the narrative had just made order of the claim and presented it in a proper way, which is what you'd want as an adjudicator, to be honest. You'd want a properly prepared claim rather than a bundle of mishmash of documents that you're having to sort of wade your way through. And again, it was probably the timing of the particular adjudication whether the adjudicator maybe didn't have the capacity or didn't want to get into a timetable and toing and froing.
Yeah, true. I mean, I think serving the expert report before the adjudication really helps in avoiding that jurisdictional challenge. But also, like, I've had situations where that's actually created an opportunity for settlement before adjudication, because if you present it in that well-ordered way, like you said, Guy, that actually might make the other party think, oh, actually they've got a real claim here and we need to do something about it, and it shows that you're ready and that you're willing to incur expense for it.
And they might not have the other side might be of the opinion they've not had everything bundled up. They might have had a change of staff, change of surveyors and change, working for main contractors do change on the project, so they might not have had the whole history, and it's presented to me in one document. Say, well, there you go and think about it, and they might just we find that I wouldn't say half of the time, but some of the time it does bring that dispute closer to a negotiated settlement, which is what we want, really.
Yeah, exactly. So I think, the conclusion there is that experts are good at helping and presenting the claim, and that it's a worthwhile investment because you might get a settlement before you actually have to adjudicate. But if you do still need to adjudicate, then you're more likely that the adjudicator is going to understand your claim and be able to get all of the points in there.
I think it's important on that, whether an expert's valuable or not, it depends on the quality of his report. Because acting as expert witnesses, you can usually tell whether a report's good or bad. It's been presented in a balanced way. So I don't think you can see when people are not balanced in their approach. and that obviously gives less weight to the relevance of that expert report.
Yeah.
Yeah.
And they've got to stick to the lane as well. That's what I think. We keep
Stick to the what?
stick to your lane. If you're a
Yeah.
QS quantum, if you're planner, delay, contract, stray away from contract interpretation. It needs to be. I think that's stick to your lane. Is what we've been taught and what we keep coming across. It's just make sure you're sticking to where you should be.
Yeah, which means, so as a party representative then, you need to take some time to think about, well, what are we actually asking the expert to do?
Yeah.
What's going to be the scope of their instructions? What questions are they going to be answering before you just rush and instruct them to do it?
Yeah.
Because you don't want their report to stray into areas that could be criticised, like contract interpretation, for example.
Yeah, which is difficult because we do, as a QS, you will operate a variation mechanism, on your day-to-day job, but it's, that's for the tribunal to decide how that is correctly interpreted, not job logs QS, basically.
Yeah.
So, yeah.
Stick to numbers.
Numbers. Yeah.
So, okay, well, what about witnesses? Because from our previous discussions that I always think in adjudication that once you start having witness statements, that can actually complicate things because you end up with a lot of duplication with the actual referral or response document. And if you've already got the contemporaneous documents like emails, etc., I always think you don't need a witness statement taking you through that. And the only time that I'd really use a witness statement in adjudication is if you were talking about a telephone conversation or a meeting where you didn't have that contemporaneous record and it was just someone's own recollection of a discussion. So I was interested if you have examples of where witness evidence has been really helpful in an adjudication or circumstances where you'd think about, well, yeah, we should get a witness statement here.
Well, I think the value again of witness statement is probably supported by the contemporaneous records. So I know we've not quite covered it, but the contemporaneous records are incredibly important in the adjudication because more often than not, and it is a documents only procedure.
Yeah.
I've had a particular situation where the witness statement, which came at the rejoinder stage, it actually defeated the responding party's case. It went against them because it was from one of their own commercial managers who actually supported contemporaneous record from the referring party. So that to me was valuable because it corroborated and a position which went against themselves.
Yeah.
So because you can't test the witness in evidence in adjudication, then
because there's no cross-examination or anything.
No, there's no evidence in chief. So that to me was really powerful. Because it clearly was not creating a new truth. It was his recollection.
So I suppose that comes back to what I was saying then, that is the question when you're thinking about, well, before we start adjudication, what do we need? Who do we need to be involved from our party? The question is, can this person actually add anything over and above the contemporaneous documents? Because sometimes I think it can look like you're not comfortable or confident enough in your claim if you've got a witness statement as well that doesn't add anything.
A good way, I've seen it before, is where you've got a load of progress photos. They're the main thing. Dated progress photos, date stamped. Remember that. Date stamped.
Yes, when you're saying that if you take a photo like on an iPhone, it doesn't have the date stamp.
Yeah, you've got to mess with you've got to go get the metadata.
You can extract the metadata.
I know, but it's a pain in it. You want a date stamp on a picture. So I know good old fashioned £10 camera. But you get your site manager who can. I found it where you've got a site manager who can talk you through the progress photos at the time, what was going on site. If it's not clear from the daily logs, and you've just got a bundle of photos, you've got a site manager who lived it and breathed it. He can walk you through the timeline at that point in time, which is quite helpful. So that's quite a good witness statement, I'd find. But
With photographs, actually, I've known it in the past, and it's been really helpful to construction companies, subcontractors. So they have a site photographer, engaged consultant or whatever, professional photographer, and then what he'll do is he'll come and ask the team, what is there anything in particular I should be looking at today? And then you can actually set him a list out of the things he needs to go and record, and then if you can corral those photographs together and and save them as part of your you can support your variation, a delay event, or a loss in expense.
Or progress, general progress, like you say. For example, can't get on with the groundworks because the scaffold's there, and there's a nice picture with the date on it.
Yeah, so that's before you even get into dispute. That's just at the start of the project, you pay someone to be on the project every day taking photos of professional photographers, so you've got that photographic record.
Yeah, I mean, it doesn't, you don't necessarily need them every day. It could be once a month, but it used to be that the project manager would get chucked a camera.
Yeah.
Just go take loads of photos. Well, that's not helpful, is it? 'Cause
we used to have I remember being training surveyor, we used to do that one. We had a load of numbers on a load of drop. That was where we took the pictures every month.
Yeah.
Every week, we went round and took 30 pictures, in that order, so we knew exactly where it came out on each one. So, and it was a Friday afternoon task, basically, is what we did, just the progress, what had happened that week. Well, I worked at a firm where we used to have an in-house photographer, and he used to come around and do the progress photos, so it worked quite well.
Yeah.
So that's a good idea then.
As long as they're directed.
Yeah.
Because they need to know what they're taking photographs of.
Yeah, because if not, it's of the entire site.
You can send anyone around taking photographs, can't you? But whether it's actually relevant.
Yeah.
And I think that's important in terms of correspondence in adjudication. When you're preparing an adjudication, make sure you're extracting pertinent correspondence, because and it's got to be pertinent correspondence, and it wants to be chronological as well and relevant to that matter, those issues.
Yeah, putting just file names are quite important.
Not just chucking everything in
at the beginning. Year, month, and date at the beginning, which is quite helpful when you're sending documents to people.
So again, during the project before this, it's helpful if you save all the correspondence with the date and.
It's just little things. It's just I know it's a pain, but it's just like put your year. It's just standard thing, and it's just really helpful when you're reviewing stuff.
I do have another tip actually, and it's when people rely on turnstile records.
Yeah.
We've had situations where turnstile records have been found to be invalid because another piece of evidence has shown that, say, a turnstile has been on free swing.
Yeah.
So people can just go in and out at their own free will. And it's also been used, against someone who reckoned they visited site every day, but they didn't because turnstile records stated they didn't. So I think, in terms of your evidence, like your turnstile records, make sure it's been consistent. So turnstiles are consistently used or whatever, or at least your signing in and out books are really good. It's.
Well,
there's geofencing on apps now as well, and all sorts of stuff, which modern technology is moving on. So anyway,
I think all really good points about how you need to be looking at what records do we have of the dispute, what contemporaneous evidence do we have to support it. I think we're straying into records. I know you both could do an entire webinar just about records, so maybe that's one for the future. But should we move on and in terms of. I mean, no one really wants to be locked into the adjudication process because of the risk and cost and time involved with it. So what about strategies you presented with a dispute to avoid it actually getting to adjudication, trying to drive a settlement beforehand? So we talked about how presenting the expert report is a really good tactic. Something that I've done previously is to actually draft the referral notice and send that across, because that shows that you're ready to go to adjudication and that you've already put in that work, really. One tactic I see a lot of people doing is starting the adjudication, so serving the notice, but without really wanting to go through with it, but just as a tactical measure to try and push a settlement. But
Calling the
for
bluff.
that, it's really risky because you're stuck. You either need to then not do anything further, which means you've lost the threat of adjudication, because next time you try, the other party will think, well, they're not serious about going through with it. Or you carry on and then you're locked into the adjudication process and you've past that time when a settlement might have worked. So, I mean, what tactics have you used? What do you think works well in terms of driving a settlement to avoid adjudication?
My first thing is make sure you're speaking to the right person on the other side of the decision maker, rather than not saying the site level might not be the right. If say it is a subcontractor versus main contractor, you want someone who's got who's got the ability to make that decision on a settlement on a certain level of dispute, which so you might need to speak to the commercial manager or commercial director even, and that's the person you need to be trying to communicate with, rather than, because they might not even know. Like, we've had that before, haven't we?
Yeah.
Where they've not, it's not been reported upstream in this contracting organisation that they had an issue on site. The first thing they knew about it was when we picked up the phone. What can I say? We're going to hit you with a £250,000 dispute next week. If you not, it's just, just because it's not being reported. So, and it got resolved at that, quite short shrift. So,
to escalate within the party before going to adjudication, just to make sure that people are aware of it.
And make sure there's provisions in there. There'll be provisions in contract and we see amendments like you've got to go to a certain person, and which enforces that it's escalation procedure. Or make sure you've notified them. Follow the procedures really.
Yeah, because like you say, it might, in the amended contract, it may say send all notices to the company secretary.
Yeah.
A notice on a project may never have gone to the company secretary, and as soon as if you're embarking on something like adjudication, then you need to make sure that notice is served on that. Has been effectively served, which is in accordance with the contract. So it would have to go to the company secretary.
Yeah.
Now, in terms of trying to, I suppose, try and reach settlement before adjudication, I've seen it in the past where a notice has been drafted and it is attached to a letter. So you mentioned the referral. We need to talk about the referral and the notice, how they work, because that's quite important. But it's actually, if you send it as an idle threat and you don't get the response, you've got to make sure, I think, that you go to the next stage.
So actually appoint the adjudicator.
Yeah.
So carry on with the process.
Yeah, because you're only going to get one chance at it anyway, really, in reality, because they'll just think, well, these guys are never serious, they just keep sending me a notice.
Yeah, which I'm thinking about where acting for the responding party and the other side just keeps serving notices and not doing anything with them. And so it loses that threat. But then I suppose if you do continue, the risk is that you're not ready. If we move on to thinking, well, okay, you can't settle it, you're going to adjudication. Yep. My top tip before starting is that you draft the referral notice first, because we've had that before where we've seen parties that have drafted a notice and then sent it and then got into the detailed drafting of the referral notice, and the nuances of the dispute has actually changed once you've got more information, and then you've moved away from what you've actually asked for in the notice.
All I was trying to remember is your notice is an executive summary of your referral. It makes it simpler.
Yeah,
just do it like that.
And you can't do that then. You can't summarise something if you haven't drafted it yet.
Yeah. Your notice is 10 pages, your referral's 30, and it's just that little bit. And make sure the redress are the same at the end. You see that anyway. Yeah,
well, that's something that I wanted to ask you. So what are your common mistakes that you see in notices of adjudication?
Wrong. Well, it's not being served. It's the service is the main one. It's not being served correctly. But we've had non-crystallised disputes or wrong redress, wrong referral.
Yeah, I think the redress is important because that's basically what the relief you seek. It's what you want out of the adjudication. You do see sometimes somebody is asking for a valuation, for example, but they're not actually asking for the money.
Yeah.
to be paid.
Where yeah, I know what you mean. I've had things like that previously. So we had one recently where I was acting for responding party. The other side was a subcontractor. My client was a main contractor. Subcontractor was clearly, when you looked at the previous correspondence, wanted an extension of time and loss and expense granting. But in the notice, they'd actually only asked for loss and expense and hadn't granted they hadn't said to the adjudicator in the notice, you know, we want you to declare that X amount of weeks of extension of time is required. So we raised that as a jurisdictional objection, and the adjudicator agreed that he didn't have jurisdiction to award an extension of time. So if all his jurisdiction extended to was loss and expense and that was tied to delay, well, he couldn't actually award very much loss and expense because he couldn't give that extension of time as well. And what you said there, Guy, that's a really good point, where you might say, oh, value the account at X, but then you need that follow-on direction as well, and that party A is to pay party B Y amount of money because of that valuation. And so, I mean, the way around that is just, all you can say is be careful, because all of the jurisdiction comes from the notice. So you need to make sure that the redress sort is drafted correctly.
Yeah, and we've seen it before. It's old now, but it used to be a fixed sum. You know, party A shall pay party B £100,000, and now we put, so whichever sum the adjudicator shall decide.
Yeah.
To give him a bit of leeway.
That's yeah.
So he says, no, well, I can't award that because I've found you due 999,000. That's nice. But
but the jurisdiction doesn't extend for him or her to actually award that. Yeah. So, and as you mentioned, the next thing is then service. So making sure that you actually serve it correctly. And a key kind of point where I see a lot of parties trip up there is applying for the appointment of an adjudicator before they actually serve the notice. And it's not through, it all seems to be sort of by not looking at the notice provisions properly in the contract. So for example, you might have where if you serve a notice of adjudication in the post, it will be deemed served the second business day after posting. Yeah. So you can't apply for the appointment of an adjudicator until after that date has passed. So we've been able to knock out adjudications before when acting for responding parties on the basis that the notice has been served after the appointment.
Yeah, I think that's another reason that your referrals got to be done first, because the referral is essentially the substantive part of your adjudication. You know, it's a document which gives the adjudicator the evidence to decide in your favour or not. So if you have some strange service provisions, like served after 2-3 business days, then you're actually giving the nominating body, whoever that may be, a short period of time to appoint an adjudicator.
Yeah.
And so some may commit to appointing an adjudicator within 48 hours, but still, a chance that they may not find the adjudicator that's available.
Yeah. So if you're in that situation where you've only got a few days to get the adjudicator appointed, a good tip then is to ring the nominating body and say, can you please expedite this because we're up against this deadline, so you get the adjudicator appointed in time. Just on that, applying for the appointment of an adjudicator. So most of the adjudicator nominating bodies, they have their own forms that you fill in and you have to pay a fee for most of them. Where have you seen parties go wrong on those forms?
On the forms?
Well, one example, I was going to say one example is that where they'll say, oh, don't appoint so-and-so because they've got a conflict of interest, or please do appoint Mr. Y because he's been involved previously in this dispute.
Yeah. Well, we've had I can't remember now, which is we've seen the conflicts on the conflicts point you've made before. We've conflicted people out who we know who we've worked with in the past.
I think you've got to be careful with conflicts. It's if it's genuine people you've been working with in the past, and you are working recently, you might be working with an adjudicator, and obviously that that'll give rise to a conflict. But I don't think you want to be overly smart on
you're wanting someone,
completing the nomination form either.
yeah, you don't want
Yeah.
to try and like lead it down a niche for someone who you really, really want. So like one with 20 years experience or whatever in forensic quantum issues, you know, there's only a few select people, you know, on that way, that type of thing, so.
Yeah, because I think you told me before that you've seen one like that where someone said something like, oh, we only want an adjudicator who has more than 10 years experience because the aim was to avoid this really new adjudicator getting appointed. But things like that, trying to be clever, creates an apparent bias, which then could affect the jurisdiction of the adjudicator. I think, so my strategy is always, if on the appointment form, you need to say that someone has a conflict of interest because you genuinely think that they do, it's worth sharing that form with the other party so that you've been really open about it. So there's no kind of scope to argue that you've tried to slip something past and get a particular adjudicator.
And if someone has been appointed on an earlier adjudication, we just say, well, they've done it before and he'll save costs, so there's less reading in. So I think that's the whole thought of it.
Yeah.
So.
Good. So referral notice, which I know we talked about the referral quite a bit already, but my question for you is to what extent do you think that a party should, when drafting the referral notice, anticipate the defences that the other party might raise? So, example, where you've sent a letter before the adjudication, the other party's responded, and they've raised in that some criticisms of your client's claim, like we've got all of these defences, or there's this wrong with it, or we've got a counterclaim. When you then draft the referral, do you get into the detail of that defence and counterclaim, or do you leave it for the other party to raise?
Personally, it's a double-edged sword at times. But I'd like to raise, you know, they'll, you know, this is our argument, well, they're going to say this, but they're wrong because of what this. So it's like you try and box off as many avenues and give them a little wriggle room as you can. But like I say, it's a double-edged sword where you could be giving them defences they're not even really, they might not even think about, you know, so it is difficult.
Yeah, well, I suppose that's the solicitor's answer. It depends.
Yeah.
Depends what you want to achieve.
True.
You know, it might be that, you know, if there's an obvious defence, right, that's going to come at you, I think as sitting as an adjudicator, I'd prefer that to be dealt with by the referring party rather than avoided, because I'd be concerned you're avoiding because it could be quite persuasive. So you don't want to give the other side an opportunity in their response to take advantage of you avoiding the obvious, which is going to come out.
And if it's like what's and all you want to present, you know, if there is a smoking gun, you know it's there, and you can deal with it in your referral. Personally, I like to deal with it up front rather than it being. So if they know it's going to come back at you. Personally, I think you just deal with it.
Well, you can manage it, and you're not on the back foot when it comes to
you've got
potentially a reply.
You've got 3 days in a reply. Generally.
Well, that depends. It depends.
Usually 3 to 7 days reply, and it's a lot of work to get done. If you've spent a month, 2 months getting your referral ready, they've got a response to do in a short period of time, and then you've got to respond to that very quickly. And so I prefer to get everything out there.
So I suppose is it a balance then between situations where the defence has already been raised, so you know what it is, and you know that the other side's aware of it because they've already raised it, in which case, yes, you should address it in the referral because you've got all that time to draft the referral, it's in your control, you can make sure you've drafted it really well. But on the flip side, if it's actually something that your advisors, your lawyers have said, this is a potentially defence they might have, but they haven't raised it yet, you wouldn't want to include that in the referral because you're supplying them with that defence that they might not have twigged on yet.
Unless you've got a good defence to their attack, basically. Unless you can counter it with something.
Like neutralise it completely.
Yeah.
It may also depend on the representation they've got on the other side as well. Because, you know, somebody who's represented, I'd like to think the representing party, be it a solicitor, you know, another a commercial consultant, would be picking up on the defences, the potential defences. So Like you say, you might just leave something hidden because they might not find, it's not, they're not, in the correspondence, it might never have been raised as an issue, so why put it forward in your referral? Like you say, you could be creating a defence.
Yeah, no easy answer to that question.
It depends, yeah.
Yeah, it depends. Good answer. So, I mean, let's flip it for a second to that we're acting for a responding party. You get served with your notice, adjudicator's been appointed. One of my first steps in any adjudication is to think, well, what jurisdictional objections could we raise? Is there a way of knocking this back so that we can buy ourselves more time? We can put the other party on the back foot. So things like, has it been served correctly? Has the adjudicator been appointed? What other things should we be looking for if we're trying to find a jurisdictional objection?
Well, I mean, you could look at, the nominating body, is it the correct nominating body? Disputes crystallised again, back to crystallisation.
Is it more than one dispute?
It can be more than one dispute.
Is there even a right to adjudicate? You get them, sometimes there's not, so. There might be, you've got right to adjudicate any time under the Act, but it might not be a construction contract, but again.
But I think you need to be careful, not just raising jurisdictional challenges for the sake of it. Because at the end of the day, the scheme gives the adjudicator the opportunity to apportion costs for his fee. And if there's, and I've seen it, unmeritorious challenges to his jurisdiction, then he will, and there's a likelihood that he could apportion cost against those jurisdictional challenges, because at the end of the day, they're eating into what is, statute dictates it's 28 days from the referral in terms of timetabling.
Yeah.
It can obviously go longer than that, there's ways of extending the timetable, but, if you're just raising jurisdictional challenges during those submission periods, then, obviously it's gonna squeeze the timetable.
Yeah, and there's, you spend time on your actual defence, really, as well, if it's meritorious challenges. It's just,
Yeah, so if you're going to raise it, make sure that it's a proper challenge, because if you're raising something that is unmeritorious, there's a risk that you will then be on the hook for the adjudicator's costs that at the time that he or she has spent dealing with that challenge.
Yeah, I mean, it could be some of it, but also I'd like to think you want to keep the adjudicator on side, because why would you be, and you see parties being overly aggressive with an adjudicator. And me sitting as an adjudicator, I don't particularly like it. It doesn't help. It's just not helpful. Because the adjudicators have, a pretty, it's a tough job. Deciding a dispute in 28 days, you don't need the parties to be overly aggressive or uncooperative throughout that period either.
Yeah, it's interesting that you said that, because in the context of timetabling, I always think, if the adjudicator asks for an extension to the deadline for his or her decision, that I feel like, we should grant it, because if not, won't the adjudicator just be annoyed? And so, I mean, what are your thoughts on that? Is it frustrating as an adjudicator where if the parties don't help in agreeing extensions to the timetable, and if you're faced with difficult parties where they won't give an extension and time's running down, what can an adjudicator do to take control of that timetable?
Yeah, I mean, sitting as an adjudicator, if I needed more time and I asked for more time, the referring party has a statutory right to extend the timetable by up to 14 days unilaterally. And if it needs to be anything beyond that, then I always seek agreement.
Yeah.
But I think it's always good practice from an adjudicator's perspective to maintain the referring party's right to unilaterally extend the timetable in any event, just in case anything unforeseen crops up. Adjudicator could get ill, and then you can't have another adjudicator step in. So I think timetabling's important, and the parties need to be respectful of that.
Just had a design, haven't we?
Yeah, well, that's a risky run. You know,
But you had an adjudicator resign, what, because the parties wouldn't agree?
Yeah, couldn't agree at times.
well, they couldn't agree the timetable.
Yeah.
So
So I suppose that's the ultimate risk then
Yeah.
for a referring party who
Start
wants
again.
the decision.
yeah, so you know, as a referring party, why would you not give extra time? Because surely you've gone to adjudication because you think you've got, you know, a more than 50% chance of winning. So why would you? I couldn't, you know, I couldn't. What usually happens is, you know, a client comes in and says, "Oh, how soon can I get a decision? How soon can I get a decision?" You know, statute dictates it's 28 days for referral,
Plus 5 for you.
plus 7 for your notice. So, you know, that's the statutory time scale. But you know, like I said, the adjudicator may need more time because it's so, you know, it's it could be a complex issue that's been referred to.
They usually do get extended. Even.
Yeah, I can't remember ever having one that went just 28 days from referral, because there always seems to be something, whether it's a bank holiday or someone's on annual leave or there's further submissions. It seems like normal practice now that in most adjudications you would have 4 submissions. So you've got a reply and a rejoinder.
Yeah.
And then sometimes you even get submissions after that, and it can feel like it goes on and on. So, I mean, I like to say to clients that you're looking at about 3 months from start to finish, and that's going to be, you know, you might be pleasantly surprised and it's quicker, but it's good to budget that because you're not going to get paid within 28 days.
No.
I would just point out there's a little nuance in terms of the timings of adjudication between the low value dispute scheme,
Yes.
CIC run, and the statutory scheme, because the referral under the statute starts on is day 0, whereas under the LVD CIC map dispute adjudication procedure, which
So you've been an
nominated bodies have
adjudicator on
accepted.
both, haven't you? The
Yeah.
and the normal adjudication.
Yeah, when you get the referral, it's actually day 1.
Right.
So, you know, there has been discussion around it being only a 27-day period in reality.
Yeah, because you're already on day 1.
Yeah, you're on day 1.
In the homeowner one as well, 21.
The JCT
Yeah.
homeowner.
I think so. Maybe. May need to be corrected on that.
So I suppose that's something, always check what the deadline for the adjudicator's decision actually is.
Yeah.
So that you're not inadvertently left with an unenforceable decision.
Yes.
And then obviously weekends are part of the timetable as well. So you may have to work weekends and nights to meet the deadlines.
Well, yeah, I mean, it's funny that with bank holidays as well, because that was one of the things that we had to take with the recent extra bank holiday that we had in England, that we had to investigate like whether that actually counted as a bank holiday for the purposes of the scheme, which we found that it did. But it's just all coming down to it's all in the detail, isn't it, with adjudication?
I always say to parties, actually, you'll be surprised how quick this 35-day, 28-day period will go.
Yeah. Yeah.
It does fly by.
Particularly if you've got to turn around a submission in a few days. So where you know, either doing the reply or the rejoinder, and you've only got a few days to put it together. Just on the decision then, you received a decision from an adjudicator. What should parties be looking for when that decision comes in? What should you check?
On the back page, really.
what the decision is. Straight
right
to the back. Yeah.
I could check the invoice.
Yeah, true.
That might be a telltale.
Well, you say that, but I mean, I've had situations recently where my clients won, but then still had to pay the adjudicator's fees.
Yeah, we've had that. I'm not a fan of that. I think that's a bit. I can understand the reasons behind the decision of the adjudicator make that point, because it's one person chasing the debt, but the person, the referring or whoever was won, might not be able to afford to pay that and wait for the money. You know, so it's a balance.
Yeah, I think
Should go.
Well, yes, I mean, just so on that, we've had, because basics is, isn't it? Like most adjudication procedures, if not all, the parties are jointly and severally liable for the adjudicator's fees, and the adjudicator has discretion to allocate their fees.
Yeah.
And traditional approach is the loser pays all of the adjudicator's fees, but it's much more nuanced than that, because there's situations where you've only partly won because there might be 100 items in dispute, and you've only won 50 of them, so then the adjudicator might split the fees. But one thing we've seen a lot recently, and I know you both have had it too, is where an adjudicator has ordered that one party pay and that they then can claim it back from the other party. So they've said, I direct that party B is responsible for my fees, but party A needs to pay them in the first instance, and then they can claim them back from party B.
Yeah.
And that means that the adjudicator gets their fees and can effectively walk away, but then it's left for the winning party to then try and claim back the fees. So what are your thoughts on that?
Yeah, well, I think it's, the thought process behind it, I think it's important to get across. It's probably that the party who wins the money will be in funds to actually pay the adjudicator's fee.
Yeah.
Well, if they get paid.
Yeah.
But then they've got to get paid.
Yeah.
And
Have they got to enforce it?
well, yeah, I mean that's the next stage, isn't it? What you could say is, you said, Carly, parties remain joint and severally liable, and you can't escape that anyway. We obviously know about the Toland situation, which tried to pass the fees on the referring party.
As a contractual clause.
Clause,
So
which has been,
the contract clauses which say that fees are allocated in a certain way between the parties aren't valid unless that agreement's after the notice has actually been served.
Yeah, absolutely. So I think, in terms of the adjudicator asking the winning party to pay, I can't, I don't know. I don't necessarily, I wouldn't project an opinion on that, because it's, it's up to the adjudicator at the end of the day. But whether that is, say, the winning party don't get paid by the losing party, and then they've got no money to pay the adjudicator, would that be a barrier to enforcing in the court? I don't know the answer to that, but I think that might be something that ends up being before the TCC.
Yeah, interesting that, because so winning party doesn't have money to pay the adjudicator's fees because they've not been paid by losing party.
Yeah.
But to get paid by losing party, they have to enforce. But would the court say, well, you've not paid the adjudicator's fees? I don't think there's an authority on that I know of. So it's interesting whether it would come before the courts, because I don't know, you'd think, I suppose there's two sides, isn't it? That the courts will always have the adjudicator's fees as a priority, that they need to be paid.
Yeah.
But then if that's a barrier to actually enforcing and the other side genuinely can't pay, then where does that get you?
Well, it's almost placing a lien on the decision, isn't it? In terms of enforcing. Maybe that's something we pick up another day, because
could talk about it for ages. I mean, just coming back to the question I raised earlier then, so things to check when you get the decision. So we've talked about the fees and what the outcome actually is. I suppose practical things like, are there any typos?
Yeah, numbers, make sure numbers add up, basically. We've had it before where we've had to check, we've checked the calculations, the interest one, which usually is wrong.
Yeah.
And it's just basically you've got the slip rule, haven't you? So you need to get them in as soon as possible.
Yes, if you spot any errors, ask the adjudicator to correct them. I mean, we've had that on one where there was actually a typo where the parties' names were the wrong way around, which flipped the actual decision, but it was clearly that it was a typo, so we managed to get that corrected. So I think...
Who was the invoice made out to?
But I think, checking for errors, because you might be able to get in terms of typos or numerical arithmetic errors.
Yeah.
But, and then I suppose from a jurisdictional perspective, you're looking at, well, has the adjudicator answered the question that was put to them? Have they exhausted their jurisdiction, or have they failed to answer a particular part of the question? Have they answered a question that's not been put to them?
Have they overstepped? Gone on a frolic.
Yeah, because that could affect enforcement. And then I suppose in terms of, you've got your decision, and if you're acting for winning party who's due some money, in terms of next steps, I'd suggest a letter that says, this is the adjudicator's decision, this is the outcome, here's our invoice, pay it within 7 days or whatever. And then that makes it really clear to the other party when the deadline for payment is, and then you can look at enforcement.
Yeah.
Did you have any other steps that you would take after an adjudicator's decision, or would you do that as well?
That's generally what we ask the winning party to raise an invoice and
Yeah.
submit that to the other side.
I mean, the only problem is with raising an invoice, you could be liable for VAT or whatever, you know, on top of the decision. So there could be a liability that if you don't get paid, you don't pay your invoice, then you're still liable for that VAT.
Or for, like, your output VAT to HMRC?
Yeah. So, I mean, you don't have to raise an invoice. You know, if the adjudicator's awarded a sum of money, then that's it. You know, it's up to the part, you know, the losing party, if you like, to pay over the money. There could already be an invoice in play, you know, from an application or whatever.
Yeah, that's a good point. So what if the other party says, like, we need an invoice in order to arrange payment?
Give them all.
Well, that probably means they're going to pay then.
Yeah, good point. Yeah.
Yeah.
Good.
Yeah, some of payment provisions ask for that. Generally, you've got to raise the invoice at the back of the cert, so just.
Yeah, following an interim certificate, you have to, yeah. Good. Well, that brings us to the end of the adjudication process. So let's see if we've got any questions to go through. Yeah, we've gone through quite quickly, which is good. We've got a few minutes left. So we do actually have a few questions in. So I'm going to pick one at random. This is quite an interesting one. So is there any way to challenge the quantum of an adjudicator's fees?
Well, again, I think the courts have dealt with the reasonableness of adjudicators'
I
fees.
think, as long as he or she spells out, you know, what they've at the time they've spent, I think it's pretty much there. Unless if you feel it's unreasonable, you raise it with them. I'm not sure on the answer of this one, to be honest. But yeah, the courts have dealt with it.
Yeah, I mean, you see a range of adjudicators' fees.
Yeah.
I think the more experienced adjudicator you get, they should be able to deliver their decision in less time.
Yeah.
Not necessarily the case.
No.
And you do see it. See some drive fees. But, you know, at the end of the day, because the adjudication process is so important, I think, to the courts, there is a range of
bit of leeway,
reasonableness in the fee, and I think you can tell. But
yeah, I think it's an interesting question because it's one where there's no set answer. I think the simple answer is no, because the court's priority is always that adjudicators should be paid their fees, and there's been case law where adjudicators' fees have been challenged as being disproportionate, but the court has essentially said, well, they've done the job and they're entitled to be paid that. And you know, there's a trust of an adjudicator that they will only charge what they have in fact incurred. And so whilst, you know, if you are a disgruntled party that feels a bit like they've been charged too much money, you could ask for a breakdown. And some, you know, adjudicators are generally willing to provide that, so you can see. But that's it, because I think there's always a risk if you start criticising an adjudicator's fees or perhaps raising a complaint that you'll end up with that adjudicator in the future, and then you think, well, is it worth it to create that animosity? And so, yeah, I think unfortunately the answer is that, you know, adjudicators have to be trusted that they are charging the correct fees that they've incurred, and if you're directed to pay them, then you have to.
I think and you know, sitting as an adjudicator, you'd probably you could create a rod for your own back if you're too explicit about what your fee is entailed, because somebody might say, "Oh, you've not looked at my referral for long enough." You've looked at referral for 3 hours, you know, but it's 6,000 pages of supporting documentation.
But then equally, you could have a situation where an adjudicator said, "Oh, I've spent 10 hours on it," and a party's going, "Well, it's only 10 pages long," and that's not fair, because you can't anticipate how long an adjudicator's going to take. So, okay, so is an adjudicator bound by previous decisions? This is another one where there's a long answer, unfortunately, I think.
Yes, I'd say. But more,
It's- Yeah, I mean, it depends if it's delivered and be persuasive.
Yeah.
I've had a situation where I've been presented a decision in my decision-making period. They say, you got to follow this. You're like, oh, okay. And then you have to consider the other decision. I had to read it and understand whether there was anything within that I had to follow, and it actually transpired that it didn't impinge on my decision at all. It was, the decision was what he was being asked to decide was quite different to what I was being asked to decide.
So what you're saying there is that the binding, if it is truly the same dispute that has been decided previously, but if it's something that actually a previous adjudicator decided at a different point that wasn't part of the dispute that had been put before you as an adjudicator, then you're not bound by it.
Well, it could be interpretation of a contract clause, for example.
Yeah.
Then, a second adjudicator coming on the pitch for another adjudication, be a brave man not to decide to follow a previous adjudicator's decision on that particular clause. Have it, it not being challenged, and no sign of any requirement to enforce first decision. So, they're accepting the first decision as valid.
Yeah. So that, I suppose the argument then would be, well, if the contract clause didn't actually apply to what you were deciding. So if it was, a clause about extension of time and you were looking at a variation, there was additional works or something. Yeah, you wouldn't need to look at the previous decision, would you? So,
No. But it might be used as a tactic as well to try and get you to decide in a particular way.
Yeah.
Any more?
Yeah. What do you do if the other party fails to participate?
We've had this. You just carry on, basically. If the other side, you make sure the adjudicator usually gives the other side opportunity, as long as to respond. But you just got to carry on. And they'll proceed ex parte. So just carry on. Drive the way to the decision, and hopefully he finds in your favour. So it's quite embarrassing if he didn't. No.
Yeah, I think I'd agree. You carry on, but I think internally within your client, you need to recognise that if the other side has not participated, it's unlikely that they're actually going to comply with the adjudicator's decision when you get it. So then you're probably going to have to then get into enforcement proceedings. So I suppose in some situations there might be a decision to be had of, well, is it worth carrying on and incurring the adjudicator's fees if they're going to have to enforce? Because if you're the only party participating, the adjudicator is going to say, well, you have to pay my fees, please. So then is it worth incurring that X amount of adjudicator's fees if you're then going to have a decision that you're going to have to get into enforcement? I suppose that depends how much is in dispute and the wider importance of that dispute to other issues.
Yeah, it's good to have an enforceable decision there, I think, because the judges, the court's favourable to adjudication, and an enforcement generally they are enforcing our experience.
There's usually quite a valid reason for it's seen as a valid reason for not participating in adjudication. I've seen it where somebody they know they're going to lose.
Yes.
Yeah. So they feel it's not worth incurring the cost of defending it.
Yeah. So then
they're just kicking the rug.
Just deal with it and then have a true value adjudication after.
Or they're just waiting for the bill that says it's technical. They're going to wait for the decision, and then the enforcement. There could be 3-4 months and wait before they have to pay that before and then run the true value. So
yes, it's a long time.
Yeah.
Well, but they still have to pay the.
I know about
for the
that
true
for
value.
5 months that went into it. So unless they want to, it gives you that time to prepare. I can see why they do it at times, but it's still,
Good. Well, thank you. I'm conscious of time, so I'll bring it to an end there. Thanks very much for joining me today,
Thanks,
Jason and Guy. And thanks to
having
all of you for listening. Really hope you found that discussion interesting and something a bit different to the usual sort of webinar format. I'm conscious we haven't been able to get to all of your questions, so we will come back to each of you separately to share our thoughts with you. And if following this webinar you have any more questions or things to raise with us, or comments or feedback, please do get in touch with one of us, because it'd be really good to speak to you. So thanks again for joining us, and enjoy the rest of your day.